Hello, my name is Peter Bricks. I'm an Atlanta bankruptcy attorney with offices in Woodstock, Jonesboro, Cumming, and Dunwoody as well. I'm here to talk to you today about why you might have received a 707B notice from the US Trustee. But first, I want to issue this disclaimer. We're a debt relief agency proudly assisting consumers in filing bankruptcy under the US Bankruptcy Code. I'd have to meet with you individually to offer you applicable and accurate legal advice. There is no attorney-client relationship with the viewer of this message. Uh, Now, you might have in your Chapter 7, and this would apply only to a Chapter 7, received a notice from the U.S. Trustee about possible dismissal under 707B. What does that mean? Well, for starters, the U.S. Trustee has 10 days beyond your meeting of creditors to send you this notice. So you file bankruptcy, you have a meeting of creditors usually about a month later, and then 10 days after that is the U.S. Trustee's deadline to send out this notice of possible dismissal under 707B. They then have to 60 days after your trustee meeting to file a motion to dismiss, 60 days beyond that to file a motion to dismiss, but it must be preceded by the notice, which comes, the deadline for that is 10 days. Why is that coming? Well, it's simple. If you are filing Chapter 7, presumably, unless you have a narrow exception, which is for a non-majority non-consumer debtor, most of your debts been incurred in some non-consumer facet, meaning essentially in a business type transaction, you then could have your case dismissed for having essentially too much monthly disposable income. You would have completed a means test, which is a 6-month look back of your income. You would have completed that to file the case. So what's happening here is either the U.S. trustees arguing, or at least setting the groundwork for potentially arguing, they're saying we're reserving our rights at this point to later argue that you make too much money under Chapter 7, your monthly disposable income, based off your means test result, meaning perhaps you didn't disclose all your income, or you claimed a deduction you couldn't claim, or a combination of the two, or not on the actual paperwork of your means test, but under the totality of circumstances. So the U.S. trustees conceding your paperwork is accurate under the income you received in the last 6 months versus minus your allowable expenses, you would qualify for a Chapter 7 discharge. They would allow you to get one. However, there is something amiss in the totality of the circumstances that you don't deserve that. And the most typical example would be, let's say, the means test, like I said, is a 6-month look back. Let's say the first month of that or the first 2 months of that you were unemployed and now you are employed. So if we were to project and say if you were employed the entirety of that 6-month period, would the means test have showed that you do not deserve a Chapter 7 discharge? If the means test would have showed that, then the totality of circumstance argument the U.S. trustee might raise is, well, in that first 2 months you didn't work, but that's not really indicative of your situation going forward. You're now in this secure, stable job, and if we were to project you at the income you're making over the next 6 months, you're clearly going to show, or really 60 months, you're going to have the ability to pay your creditors, your unsecured creditors, $700 a month. And then if you continued at that employment for 60 months, 700 times 60, that's $42,000. Your creditors could get $42,000 over that 60-month period. So we're going to challenge your discharge on the basis you make too much money. So if you get that, now we get that notice, you're probably going to hear further from the U.S. trustee. There might be a discovery period. They might ask for your filing pay stubs or your spouse's pay stubs, even if your spouse didn't file the case with you. They might ask for proof of your mortgage payment or something along those lines. Then there could be some other variables like, are you paying student loan debt? Because that's not an allowed deduction. Are you contributing or repaying a 401k loan? That's not allowed deduction. Do you maybe have some extraordinary expense that most people don't have, like you give a lot to charity, or your kids need a special education or is a special needs child? It's really going to get specific down to the facts of your case. But at the initial stage, the point to know is if you're getting that notice, there's at least the possibility the U.S. trustee thinks maybe Chapter 7 is the wrong chapter for you and you should be in Chapter 13, which is the repayment chapter. And the road's not all clear for you to get a Chapter 7 discharge. And then the next couple months are really going to determine what happens. Is the U.S. trustee going to go as far as filing a motion to dismiss your case? Perhaps you're going to sit for what's called a 2004 exam, which is a deposition. It could go a variety of ways. So if you get that notice, you should certainly contact your attorney and ask why you got that and what can be done to fix it.